Hello and welcome to Florida Pulse, where we chat about topics important to you. Our conversation today is about conviction integrity units, what they are, and why they are needed. My name is John A. Torres, and I will be your host today. I'm the engagement editor at Florida Today, which is part of the USA Today network. I'm also the creator and host of the Murder on the Space Coast podcast, which focuses a lot on wrongful convictions. Before I introduce our amazing panel today, I just want to read you the opening line taken from the Orange County prosecutor's policy regarding conviction integrity units. It says, quote, "The wrongful conviction of an innocent person should be every prosecutor's greatest concern. A prosecutor's highest priority should be ensuring innocent people are never prosecuted." With that, I'd like to introduce our panel. Seth Miller, a great lawyer and president of the Innocence Project of Florida. Erin Moriarty, a friend and incredible journalist with the long-running CBS show 48 Hours. And lastly, I'd like to introduce attorney Ginger Miranda, who heads up the Conviction Integrity Unit for the Orange County Prosecutor's Office in the 9th Judicial Circuit here in Florida. Welcome, everybody, and thank you for taking the time to be with us and to chat about such an important issue. Ginger, I'm going to start with you. Just in real general terms, can you tell the public what a conviction and integrity unit is?
Sure. So the purpose of the Conviction Integrity Unit is to prevent, identify, and correct false convictions. So, the duty of the prosecutors to seek justice, and our unit does that by remedying any false convictions.
And Seth, would you mind just talking about the need to have these things? I believe we only have 4 in the state of Florida out of a possible 20. I think we have 20 judicial circuits and only 4 integrity units. Can you talk about the need for it?
Yeah, so again, I run the Innocence Project of Florida, and for many years we've been overturning wrongful convictions. We've gotten 28 individuals out, spent more than 588 years in prison for crimes they didn't commit. And until recently, getting someone out of prison who was innocent, who was wrongfully convicted, essentially took like moving mountains. It was a Herculean task. And often the reason it was a Herculean task was because prosecutors' offices were standing in the way of justice. They opposed every effort by organizations like mine or defense counsel or even pro se litigants to try to figure out the wrongful convictions and move the courts to vacate their convictions. So I think the importance of the conviction integrity model is that it's an innovation that allows for collaborative justice. It takes out that adversarial process and takes prosecutor and defense attorney or prosecutor and defendant and has them working together to remedy a wrongful conviction. So the main benefit of this is that it leads to justice more quickly. Of our last 4 or 5 people we've gotten out, they've been collaborations with conviction review units, and they're collaborations that allowed from beginning to exoneration, the ability to get that person out in a matter of months or maybe a year, as opposed to having to litigate a case at many different levels of the court system over the course of many years. That, of course, frees an innocent person more quickly, which is more important. It returns them their freedom at an earlier time, saves the state money in terms of having to pay later for wrongful incarceration based on the length of wrongful incarceration. I think it just gives the public a sense of they can feel good that these parties are working together to do right, and gives them confidence in the system that even when the system finds an error, it doesn't just put its head in the sand and pretend that it doesn't exist, and rather seeks to remedy that error. And so these conviction review units are needed. They're important. It's an important innovation, and it's our hope that all prosecutors' offices that want to have one and want to do this work and do it in a way that is appropriate and right would make this model part of their efforts to seek justice.
That was a lot of great information there, Seth, that I want to ask you about in a second. But I want to ask Erin, you've covered a lot of cases, Erin, obviously. And is there one in particular that you believe would be perfect for a conviction integrity unit to look at?
Well, that's a tough question because actually, it seems to me when I've been looking at the way conviction review units, some of these are complicated. The case I'd love a conviction review unit to take a look at, of course, is the case of Crosley Green, which is a Florida case that you, John, Seth are all very familiar with. But it's a pretty complicated case, and I see that in some cases, conviction review units don't want these extremely complicated cases. The reason why I would love that case to be looked at, I'm borrowing this line, I didn't come up with it, but conviction review units or conviction integrity units have been described as innocence projects on steroids, because they have, usually these conviction review units have access to files that defense attorneys don't. Innocence projects don't get access to unless you have a cooperative prosecutor. And I believe in the Crosley Green case, there would be so much in the file that would help determine how this case should be handled, whether it would end up with an exoneration of Crosley Green or not. There are so many questions about this case. And the other reason why you want a conviction review unit to take a look at a case like Crosley Green is, let's be honest, the Attorney General's office in this case has always just, as a matter of course, fought every single appeal. And the latest decision, the judge clearly took all the facts, the judges, the panel of 3 judges took all the facts most favorable to the state, which is what happens in appellate courts. The conviction review would actually look at the case from the beginning, look at innocence or guilt, and not just look at the case from the perspective of the defense or the perspective of the prosecution, but actually look at the case. And I think this latest decision was most disturbing to me as a reporter, because after 33 years on a case, we are still almost where we were at the beginning, accepting facts that make no sense and ignoring facts that should have been looked at from the beginning.
As you can tell, Erin is not very passionate about that Crosley Green story. Anybody in the state who's watching outside of Brevard County or Central Florida, please just Google Crosley Green, Crosley Green, and just read through his case and the stories that we've done. Her great reporting on it on 48 Hours. She's done, I think, 2 or 3 segments on him over the years and all that. Ginger, can you walk the layperson through the process? I mean, everybody in prison is innocent, right? At least, judging from all the mail that I get from inmates. How do you discern which ones to follow up on, and what is the process?
John, can I just first start off by correcting? There's actually 5 conviction integrity units in Florida now, not 4. So we're very happy that that number is actually growing. So that is our newest number. And yes, I can walk you through it. First and foremost, we are limited by our jurisdiction. So we only look at the cases that arise out of Orange or Osceola counties, because that's the 9th Judicial Circuit. And so that's where we start off. So we get cases from all over the state, believe it or not. We are able to refer some people to the other CIU units that exist. But if there is no CIU unit in their circuit, that's where it really ends for what we can do, because we can't help anybody outside of Orange or Osceola County. Secondly, I just want to point to the fact that one of the main things that helps us decide whether or not to take a case is that the case must present a plausible claim of innocence. So we're not just looking at every case. We're looking at a case where in their application, which we have up on our website, they are able to articulate to us that there is a plausible claim of innocence. And that's one of the fundamental things that are required so that we can even look into a case. And so that's where the process would begin, would be through an application. And then we would review that application to find if there is a plausible claim of innocence. and then we would get started on reviewing the case from there.
Excellent. Seth, I've read a report, I think it was the University of Michigan, I'm not sure though, that said that about 60% of wrongful conviction cases involve eyewitness testimony. Can you tell us what we've learned over the years about the unreliability or relying too much on eyewitness testimony for convictions?
Sure. And so I think it's first important to note that we are now sufficiently down the line that we have a very large data set of what are now over 3,000 people exonerated that are documented through the National Registry of Exonerations out of University of Michigan since 1989. So from that, so it's a list of unfortunate people who had this tragedy happen to them. But the fortunate thing is that we can look at all of those cases and assess, why did the wrongful conviction happen? What were the contributing causes to it? So what we've learned, and as you've mentioned, is that eyewitness misidentification is one of the leading causes of wrongful conviction. And particularly in cases where people are exonerated through DNA testing, it's like 70% of those cases had at least one or more witnesses, victims or witnesses, misidentify the person who was wrongfully convicted, later exonerated through DNA testing. And so what has sprung up is a more than 40-year history of social scientists trying to figure out, why does this happen, doing scientific experiments. And what we found is that there's all kinds of factors that impact eyewitness reliability. Some of those things are things that we can control, like how we prepare a lineup, a photo lineup, or how it's administered to the person. Then some things that we just can't control, like what's the lighting, or does the witness have good eyesight, or how far away were they from, excuse me, how far away were they from the, what they saw, and all these things go into a stew that impact the reliability or unreliability of the eyewitness identification. And so what we try to do in cases is, when we have an eyewitness identification, we ask those same questions, like what factors exist? Are there some suggestion that this eyewitness identification might be problematic? And we use that as an indicator of potential innocence that allow us to say, okay, we might want to look more deeply into this case.
Erin, Seth just mentioned, like photo lineups, and I don't want to make this whole thing about Crosley Green, but there's a big problem with the photo lineup and the identification from an eyewitness in the Crosley Green case. Can you tell the viewers what it was and what happened there?
Well, and it's a lineup that wouldn't be allowed today, but if you read the most recent decision by the appellate court, well, it wasn't that bad of a photo lineup. The problem was that there were 6 pictures put, and Crosley Green was in the what they considered to be the prime spot, and his picture was darker than the other individuals who were put in the lineup. But more important, the witness was told that the suspect was in the lineup. From what I understand, this is a lineup. I know that the prosecutor who handled the Crosley Green case told me on camera that he would never use that lineup today, and it wouldn't be allowed, but it was allowed back then.
And sticking with you, Erin, for another one here, I recently read that there were, in 2019, there were 143 exonerations. These exonerees spent a total of 1,908 years in prison for crimes they did not commit. You have reported a lot about this over the years. In your opinion, why do prosecutors, not all of them, because we have Ginger here, thankfully, but why do prosecutors just seem really bent on protecting or defending these wrongful convictions until the bitter end?
Well, I mean, I think there is, of course, the attitude that if there's a concern that if we take another look at every one of those cases, we'll clog the courts. I think there's a concern that, as we have found in New York, that sometimes there are specific members of law enforcement who are more connected to those cases, so that if they decide to overturn one case, they could open the door to overturning many cases. Even with conviction review, and I'll be curious to see what Ginger thinks. So I am working on a case that will air on Sunday morning this Sunday. It is a case of a woman who was, and her boyfriend, they were convicted on the basis of faulty forensic science. And that is another major reason why people are wrongfully convicted. About a quarter of the people exonerated, there was faulty science involved. And it still took 35 years for this woman to be exonerated. She was exonerated with her boyfriend. He unfortunately died in prison, so he was exonerated in death. But 35 years, even with a conviction review unit. And so it was a wonderful thing for this couple to get their names back, but they lost everything they had. He lost his life. The child who died, they were wrongfully convicted of death of a 4-year-old. The killer of that child never faced justice. And so, so even with conviction review units, it's still taking too long for justice. But I think that what I'm finding, like in Missouri, we have conviction review units in Missouri where the attorney general, as a matter of course, is fighting them. Just, forcing them because he believes that every one of these cases should be adversarial. Exactly what, John, you said at the beginning, and Seth, that this shouldn't be adversarial when there's enough evidence that someone was wrongfully convicted. The prosecution and defense attorneys should be working together to get to the truth. But in Missouri, there is a man right now, Lamar Johnson, who is sitting in prison 3 years after a prosecutor who did a very in-depth investigation determined that he was actually innocent, and he remains in prison because the attorney general is fighting. So you actually have the state versus the state keeping a man in prison.
Wow.
Sorry, that was a lot.
No, that was great. And Seth probably has something about Wilton Dedge has a similar thing. But I wanted to get with Ginger, and I should have announced this earlier. You don't need to have me prompt you to speak. If you guys want to chime in on something, please do. Okay. Ginger, would you like to also comment on that?
Well, yeah, I think one of the there's two really important things that I wanted to comment from that. One was that, it's really important to understand in the criminal justice system that the prosecutor has a duty to seek justice, not just convictions. And that's not just lip service. That's actually in the American Bar Association standards for prosecutors. So, I think that it's important that when we come across cases where, we see someone just going after a conviction, it's really important that we realize that's not what the job of the prosecution is. And it's important to know that for the second reason, which is that as noted in this other case, the real perpetrator, the person who committed this crime, may still be out there, may still be committing crimes, may still be posing a danger to society. And that's why it's so important to get it right. We may not have gotten it right the first time, but as a conviction integrity unit, we can reinvestigate, find the real perpetrator, and hold that person to their crime. And I think that's the other part of it that's really important. I mean, it's devastating that we have innocent people serving all of these years in prison unnecessarily, but it's also really, really dangerous that we have people who have committed terrible crimes that were not accounted for because of some issue in the original investigation.
I mean, Ginger, I'd love to ask you then, because you are absolutely saying the right thing, and that's what it should be, that prosecutors should be interested in justice. But at this point, I think there's only around 103 conviction review units. Some of them, what they call conviction review units in name only, they exist, but they're really not taking a close look at cases. but there are what, 2,500 jurisdictions, and most of those do not have a conviction review unit. So why not?
Right. It's my position that they should, that all of them should, that it's important. And the fact that going back to, what are prosecutors supposed to be doing? Well, we're supposed to be stimulating efforts for remedial action. So when we see an inadequacy or an injustice happening, it's incumbent upon us as prosecutors to try and fix it.
I mean, let me just say, I think that these things take time, and I don't want to be, sound like too much of an incrementalist here, but I can tell you that even in Florida, with the longest running conviction integrity unit being around for about 4 years, you still see that you have, like, my organization will bring a case to the conviction integrity unit, and we might move it along at a nice pace, and we might come to some good, positive, collaborative result at the end of it. And I bring a case that was pre-existing the conviction integrity unit that is, being dealt with in that office by the other side of the office, who, their appellate unit, and they have a completely different approach. So this is the same office taking a totally different approach, and they've elected a prosecutor who's committed to conviction integrity work. And I only say this to say that the conviction, the lessons, the behaviors that we're learning, and the behaviors that we're exhibiting in the conviction integrity model, they are not necessarily finding their way into all aspects of the office for the front end work. How are we making prosecutorial charging decisions? What are we doing with questionable evidence in terms of being the proponent of it? What do we do when we get evidence that's exculpatory? Are we turning it over? Are we maybe taking a new look at the case? And I say that only to say that I think it does take time. And that is because when a prosecutor comes in, gets elected, like they do in Florida, and has a vision for how they want to change the system, they, like, my organization and others, are disruptors. And there are still people that work in those offices who don't believe in those reforms and the conviction integrity model that still persist and are there. And of course, you can't necessarily just fire everyone. So I think that the importance here is not only the back end work that we're doing, but over time, every time that office brings in a new class of new baby prosecutors every year, that they need to, continually train those folks in these reforms, in the new way of doing justice. And over time, we'll have that change. And I think it's going to take a lot of time.
Right. And I agree with you on that. And the other thing I'm finding that there are well-meaning prosecutors who have to work, though, with the local sheriff, local law enforcement. And so if you're bringing, as an Innocence Project, a case that involves a coerced confession, then all of a sudden this prosecutor has the problem with a law enforcement, with a sheriff's office or a police department that are saying, we did it by the book. And then you're running, like in St. Louis, Kim Gardner actually has a list of cops she doesn't want to work with anymore. And so now she wasn't very tactful about it, which I don't blame her, but now she's having real problems, and it's interfering with her ability to take a look at new cases. She's the one handling the Lamar Johnson case, and it's hard not to believe that she stepped on so many toes trying to reform the system that she has made a lot of enemies. And unfortunately, the result is it's very difficult for her to push these wrongful convictions through. I get it, Seth. I know it takes time. But when I met this Joyce Watkins, who's now 74, and this is a woman who had no criminal history and was convicted based on really bad medical evidence that we now know, science has changed. And to see what she lost everything. And so it's hard. I'm happy for her, but it's hard to say this is justice 35 years later. Her boyfriend died. It breaks my heart. That's a simple way to put it as a person on the outside covering this story.
I want to point out that conviction integrity units, we work to prevent false convictions as well. So I do want to bring up, like, I know in our office, we do train our new attorneys in what we do as far as conviction integrity, because a conviction integrity doesn't just happen on the back end in old cases. It also happens in brand new cases and what's going on currently. So if a prosecutor's office has a conviction integrity unit, it's incumbent upon them to be working on preventing false convictions as much as it is to correct prior false convictions. So there's that part of it too, that's really important as a conviction integrity unit, that you're not working just on identifying these cases, but on also preventing them from happening again.
I mean, Ginger, how do you prevent, this happens all the time in prosecutor's office. So when we're talking about faulty forensic science, or just science that has changed, we'll say in shaken baby, that there's a practice among prosecutors to bring in the medical examiners or the medical experts who are considered, child abuse, medical experts. And so the same kind of thing happens over and over again, where somebody is wrongfully convicted in these shaken baby cases. How do you prevent that?
Well, I think it's important for all prosecutors to receive the proper trainings, especially when it comes to the scientific standards. Here in Florida, we have Dauber. So it's important that that training occurs early on. And whenever someone has a specialized case, we, the state, have the resources to contact our medical examiners and state experts to learn ourselves what it is that the science is, so that we can better make that decision about whether or not this is a wrongful conviction, or if this is a proper conviction and this person is actually guilty.
But that has to be done early on. What happens, though, is once you've got the case and you think you've got a perpetrator, then you're going to build up the case. You're not really, at a certain point, you're not looking for, is that person innocent or not? You're looking, and there's plenty of medical experts who will say, oh yeah, that is absolutely child abuse. And so I guess what is being done at this time to get it early before the prosecutor then just has to build a case against that person, and it's really hard to turn, the car around.
Right. Well, Erin, I'm going to go back to my original statement, which is we're not about convictions, we're about justice. So if at any point in our case, whether that be when we first read an arrest report or we're preparing for a trial, if something comes to our attention that just doesn't smell right, doesn't look right, doesn't seem right, it's incumbent upon us, because we want to know the truth. We want to make sure that the person that is being held for this crime is the correct person. And so it's an ongoing obligation of the prosecutor to assure that their case is a solid case, that the evidence that they're presenting is good evidence, and that the whatever experts they're using or whatever evidence that they're using, that fits the standards and also passes the sniff test. I mean, let's be honest, a lot of these are calls that are made based on what the evidence is in front of them. And sometimes what we found is that sometimes there is evidence that comes out later on with newly discovered evidence that then changes the case. But you have to look and see, okay, at the time, what did they have to rely on? Now we know better, we can do better. Isn't that right? But at the time, they have to rely on the evidence that they have to seek justice.
Great stuff, guys. I think that we have a chime in from Seth here.
Yeah. And let me just say, to Erin's point, I do think it does require bold action. I think, Erin, you had mentioned, these Brady lists that exist, which are law enforcement officers who have committed acts of misconduct or have lied in cases, and the prosecutors now publicizing these lists and saying, we're not going to prosecute cases with these law enforcement officers in that. And that is a remedial measure that has real lasting effects, but it's hard, right? And I think it's a bold action. I think in terms of shaken baby syndrome or any kind of forensic or medical evidence that has been proffered by experts in a way that is not accurate, I think it's important, particularly for new elected prosecutors coming in who have bold visions, to say, we're not going to present cases where this expert gives conclusions about abuse because they have a long-standing history of making false opinions or allegations that have, put innocent people in prison or taken children away from families wrongfully. And again, that's hard to do when the state has been relying on that expert for, in some cases, decades. But that's the kind of bold action that's required that sends the message. We have to have confidence that the evidence we're presenting both passes sort of minimal standards of reliability, but we think is sufficient to send someone away for, in some cases, many years or their whole life. And that is what is needed. I mean, Erin, to answer your question.
But Seth, I just want to bring up, isn't it very difficult? You're talking about bold action, but when you're talking about child abuse and a child died and there may have been the wrong person convicted, that is what I'm finding. I mean, it takes a very brave prosecutor.
It's fraught with politics for sure. And
a brave prosecutor. She just said it takes a brave prosecutor, and I love hearing Ginger's take on this and how they're training the younger attorneys that are coming in. A brave prosecutor in Brevard County many, many years ago, but was his name was Samuel Bardwell, and he was a prosecutor who quit the prosecutor's office because they were using junk science. John Preston, he was a dog handler.
Got me going.
Yes, he was actually found to be a charlatan, a fraud, a total phony. But Sam Bardwell said he was being pressured by the prosecutor's office in Brevard County in the 80s to use Bardwell, and so he quit. And we know that John Preston helped to put away innocent people: William Dillon, Wilton Dedge, Juan Ramos. Gary Bennett, who I believe is also innocent, is in prison now, for life, has been in there for almost 40 years, mainly because of John Preston. And the prosecutor in the case, during closing argument, said that John Preston's dog scent malarkey was the equivalent of a fingerprint on a murder weapon. So I'm really glad to hear, Ginger, that this stuff is happening, although I'm also angry at you, Ginger, because you kind of stole my closing, which I was saving for later, that when you put innocent people in prison, the real killers are out there, and it's bad, it's dangerous. I did want to ask you, Ginger, if I read somewhere that some integrity units, and it sounds like your office is amazing, but I have read that some of them are not being trusted or are not being accepted by other attorneys because they liken it to an internal affairs office, like sort of like blaming and shaming them for bad convictions in the past. Have you heard of that or seen any of that?
Well, I think that comes from the fact that when a defense or a defendant brings forth a claim of innocence, right, the claim comes to the prosecutor's office, and that is this very same office that secured the conviction in the first place. So why conviction integrity units are important is because we are separate and apart from any of the prosecution that goes on in this office. So we have an independence that allows us to do an independent review and an independent investigation that does not involve anyone that was originally involved in the prosecution of the case. That gives us a really good outside view that's not at all hampered by trying to maintain a conviction, because we're separate and apart, so we can look at it independently. And because our unit is not charged with any sort of prosecution, we can do that with a totally different mindset as far as being able to review and investigate some of these cases.
Ginger, is your background defense? Because what I read about best practices in these conviction review or integrity units is to make sure that you actually have attorneys who have defense background.
Yes, I was a defense attorney for 24 years.
That's what I
before coming to this
sound
position.
Like one.
Yes, well, it's important, and having come into this position, I see now that it's really important that confirmation bias is something that we see a lot. And so it's really important, coming from a defense background, having that not be the case. So being able to look at the case from different angles and not necessarily just from one viewpoint. So I do think that being a defense attorney, being a past defense attorney, has given me a certain view. And another thing that I want to say is that having come in, I always thought the prosecutors had all the power, right? The prosecution, once they say that this is right or wrong, then that's it, right? They say yes or no, it's done. But the truth is that the power does not just lay in the prosecution. And as you guys have pointed out, even when we say there's innocence, right? Even when the prosecutor's office has said in other cases that, a person is innocent, we still have the court to go up to. So in that case, some of that delay may be the judiciary. And so that's another agency that has to really rework and relook at how they look at these cases. And unfortunately, there's not a lot of guidance because we are so new. There's not a lot of guidance in case law. And, hopefully soon we can have a statute which will address this and allow prosecutors the opportunity and the power to present these cases outside of the normal post-conviction motions that limit us so terribly. I mean, when we have a case where we're saying someone is innocent and the court is saying something like, oh, well, you're time barred. Well, no. This is manifest injustice that you're telling me we're time barred to show you that we have found evidence that this person is innocent. So
Well,
that's when we come to statute.
I was just going to say, Missouri needed a law. Missouri passed a law last year that gave prosecutors the right to go to court because the Supreme Court in Missouri had ruled they didn't have the right. And right now in Tennessee, which I think is odd, if the prosecutor, Davidson County prosecution has a really great conviction review unit, but if they believe someone's innocent, they need the defense attorney to file, because they don't have the jurisdiction to go back into court.
Well, we don't either.
Here. Yeah, it's the same.
We
thing
don't have the power either.
Oh my gosh!
I know. So I always thought the prosecutors had that power, and now that I'm a prosecutor, I find out nope, don't have that power. So hopefully the legislature will enact a statute in Florida and fix that problem and help the judiciary to see that in these cases of innocence, there has to be a finding of manifest injustice.
I just want to get this in because Erin said something earlier about a case that has proven but the woman had to stay in prison for years after the fact. And my producer, Rob Landers, he mentioned in our little chat here, innocence is irrelevant, and which is a line that I hope Seth Miller will explain. And it's a headline that I've used many times in columns that I have written. So Seth, can you tell us about an extreme case about innocence being irrelevant?
Yeah, so my recollection is that in the Wilton Dedge case, which you referenced, and this was a John Preston dog handler case out of Brevard County, was later exonerated through DNA testing. There was some dispute about when they procured the DNA testing and whether they were too late. This is before we had a DNA testing statute in Florida. And so basically saying you should have gotten the DNA testing earlier, yet even now you have the results and they demonstrate your innocence. The state was arguing that you can't use those results because you're out of time. You should have done it earlier. So it's sort of I would say the most stark example of heightening procedural bars above the rights of people. And the AG is making this argument in an appellate argument. And I wasn't there, but my understanding is that the appellate judges were sort of aghast, and they asked the assistant attorney general, so are you saying that innocence is irrelevant? And they said, yes, that's what we're saying. And of course, they overturned Wilton Dedge's conviction. He got later exonerated. And so that's the mindset. And so what Ginger, I think, is referring to is that is the mindset that still many prosecutors, many appellate prosecutors, and many courts we're still within that mindset. And the mindset and the approach of the court system is not caught up to even the work that we've been doing for 30 years at innocence organizations, and certainly has not caught up to this innovation of conviction integrity review. And so I think that the law has to update to take cognizance of what is the truth, which is that wrongful convictions do happen, and we need to have a different process that doesn't subordinate the rights of people to arbitrary procedural restrictions.
I mean, Seth, wouldn't you say, and I've been doing this a long time, wouldn't you say one of the reasons why we need conviction review is because generally, and I am, simplifying this, but in the appellate courts, it's not looking at the verdict. It's not looking at guilt or innocence. It's looking to see whether the procedures were followed. And that's really all that matters. And if you can't come up with some amazing new evidence that wasn't available back at the trial, or some significant constitutional violation that would have changed the verdict, then you could be an innocent person and spend the rest of your life in prison. Isn't that accurate?
You're totally right. Is that I think when a court gets a case, I think their first inclination is to say, how can we get rid of the case based on procedural reasons, instead of simply looking at the merits of the case. And it's sort of, I would say, we've forgotten about this idea that if the evidence as we understand it today demonstrates that someone's wrongfully convicted, then that is a grave injustice. And we need to be doing everything we can to try to remedy that. And so the problem is that most post-conviction cases don't have claims of merit. And I think the way the court has dealt with an overburdened system where most individuals in prison are filing frivolous, I shouldn't say most, many are filing frivolous claims, is to put very strict procedural restrictions that set up booby traps for those individuals. And you have to file using the right words, file at the exact right time. If they're even a moment late, doesn't matter the strength of their claims or the strength of their evidence of innocence, it's too late. And that has to change. We're 3,000 plus exonerations down the line here. We have, as you said, over 100 conviction integrity units around the country. I think it's time that we adjust that model and create innocence exceptions, manifest injustice exceptions to everything. How can it be that someone has to stay in prison because they didn't file a claim at the right time, where the prosecutor, their own look at the evidence today, agrees with the defense that this person is wrongfully convicted? We have a client that we have an agreement with a conviction integrity unit that this person was wrongfully convicted. We present the motion to the court, and the court says, this is not newly discovered evidence. You didn't file at the right time. And now our client might be the only person in prison in Florida where the prosecutor and the defense agree that he shouldn't be there. So that can't be. And then so now we have to appeal. He's 77 years old, and hopefully he lives long enough to outlast that appeal, and hopefully we prevail. But there's no guarantee we will. And so it's an outmoded system that needs to be updated.
We are just about out of time, folks. I am so sorry, but I want to give you all a last word. If there's something you want to add or say, or just let the public know something that they should, please, each, go ahead. Ginger?
I did want to say, John, that one other thing why conviction integrity units are so important is that our units are tasked with making sure that the victim is also updated and knows what's going on and gets the information about what new investigations have been revealed, and to explain to them what's going on throughout this process. And I think that's also so important. And we are placed in a position where we can do that.
I just would like to add is that I think the press plays a part in this too. In the Kevin Strickland case, a man who spent 44 years in prison in Missouri, it was the Kansas City Star investigation that kind of propelled the prosecutor in Jackson County, Missouri, to really take a close look. So it was kind of a joint between journalists, a prosecutor open to the idea that her office might have put someone who was wrongfully convicted, and then the Midwest Innocence Project that brought Kevin Strickland to them, that it takes a village to make the system work.
And I guess what I would end with is that this is a political problem as well. And that means that when you're prosecutors, whether you call them states attorneys or district attorneys, wherever you live, in every place in America, these folks are elected. And therefore, you have an opportunity to elect the kind of prosecutors you want leading those offices, prosecuting cases in your area. And if in that process you find out that a prosecutor who wants to seek that office and wants you to give them that trust and that responsibility, doesn't believe in looking backwards and remedying wrongful convictions, does not want to put a conviction review unit in place, doesn't believe in training their prosecutors to be sensitized to issues of wrongful convictions, and that is a person that, if you're a person who cares about justice, you should not vote for, and you should seek something different. And so I think this not only is a process that, or something that we need to try to remedy as players in the criminal justice process, but people have the power to elect their prosecutors, and we need to do a better job collectively of electing the people who have the proper vision for how justice should be done in this country.
I can't thank our three panelists enough. Erin, Seth, especially Ginger, because she filled in last moment. Yesterday we had an issue and we had her fill in. She was fantastic. This was a great conversation. I could do this all day long. I mean, my brain is just a buzz right now with stuff. I just want to leave our viewers with a paraphrase from a quote from Robert Jackson, a federal prosecutor who wrote this in the 40s. He basically said that prosecutors always win, even when they lose a case, because justice has been served. And wouldn't that be nice if that was always the case? Thanks again. I'm John Torres. I was your host. Check out my podcast. It's called Murder on the Space Coast. Check out 48 Hours on CBS with Erin Moriarty. And thanks for tuning in.